Howdy. Again, apologies for my voice. I just can't shake this. This is going to be a very kind of short lecture, and I hope you're not disappointed in it. And here's why. I don't care about all the details of HIPAA and GLB and these others. I want you to know those laws. But we're getting into a very interesting part of our semester, and we're going to start talking about privacy. This is from Chapter 9. One of the things you want to do is take some time and go look at the 1974, typed it wrong, Privacy Act in the United States. I always find this interesting since it does not define the term privacy. I want you to take several minutes after this video is over and look through this act and how well laid out it is in the Department of Justice website. Now, here's the statutory text of the law. Statutory meaning it is a statute. Obviously, it's the text. We could look at it. It's rather boring. Do I want you to read this? Not so much. You know, if you want to read it, good. Rather, what I want you to do is to look at how well this has been organized to teach us about the privacy. Now, the Privacy Act of 1974 applies to government agencies and how they have to safeguard your privacy. Now, think about it. This was 1974. The 60s and 70s were pivotal in court decisions and more of an emphasis on privacy in the United States. 1974, yeah, it's been amended a few times, but what I love about this is the Justice Department here takes and does an overview of it and updates it every few years. So it's 2015, not bad. So this is what I'd like for you to go through and look at and read. Now, it's 317 pages. Obviously, I don't want you to read the whole thing, but I want you to see how this is set up. So instead of reading the law, it'll say, okay, here's the definitions of the law: agency, individual, maintain record systems of records. Here's the different conditions of disclosures to third parties: the need to know, FOIA, Freedom of Information Act, census, National Archives, law enforcement request, health or safety, Congress, GAO, court order, debt collection, and then possibly just look through at some of the things that may interest you. For instance, the individual's right of access. This should be hyperlinked, but it is not. Criminal penalties. I don't want you to have to read this. This is just how this is done. And like I said, every few years, this is updated. And let's go back to the law. Now let's say, I'm kind of wondering. And you come down to the table of contents. Again, here it is. It's what's actually in that PDF, right? But it's all laid out nicely for you to understand, okay? Just what we were going through. Oh, I want to look at agency requirements. Let me just pull one here randomly. So it will give you the subject of the law, the text of the law here. Here. Okay. Here's the reference, and of course we know now this is federal law from USC, and then it's going to give you a comment. It's going to explain this. Now, why I think this is important is, one, this is a keystone act. This is a foundational act on privacy in the 70s, and we build off a lot of this. And two, when we get to GDPR later this week or next, you'll find they don't do anything like this, okay? So this, you can pick out any part of the law. It's going to give a comment. It's going to tell you to see a personal law or to look at a court case. And so it tries to be very good at explaining this law to us. And that's very important. So like I said, I just want you to take some time. Don't get all caught up in it. It's very long. Pick out something you like Social Security number usage, and look at this. Section 7 of the Privacy Act, found here, provides that it shall be unlawful for any federal, state, or local government agency to deny to any individual any right, benefit, or privilege provided by law because the individuals refused to disclose his Social Security account number. Didn't know that, huh? But yep, that's it. That's in the federal law. Also, please be sure you realize that the Privacy Act only applies to federal, state, or local government agencies. Okay? And then look here, there is a General Information Office of Privacy and Civil Liberties. We have a Chief Privacy and Civil Liberties Officer. We have a Deputy Director. We have all of these mechanisms in place. So a lot of the criticism when you hear about GDPR is a little bit of ignorance. While our philosophy of privacy may be different, and that's a topic for a later lecture, we do take this seriously. Okay, so let's get back. So here's all the different privacy laws. And like I said, they all grant us rights. HIPAA's about medical, Gramm-Leach-Bliley's financial. Video Privacy Protection Act came out of a case in the 80s, just unbelievable. A gentleman named Robert Bork was being considered for the United States Supreme Court. By the way, he was not confirmed. And a local newspaper went to his video store, which this is before the internet, before downstreaming, before Hulu, Netflix, and Amazon Prime Videos, and got a list of the videos he had watched in the previous year and published that list. And so Congress said, there's just something not right about this. And so they passed that law, and even though we no longer have video stores, there is part of that still applies to Netflix, Hulu, and the like, that's considered private data. Now, if we were in class, I would ask you all, what do you consider private data? Do you consider the books you've read? The videos you've watched? How many times this past year you went to the dentist? I don't know. There's some things we clearly think are private data. And then we have this gray area of, do I care what videos, if people know what videos I watched? Do I care if people know what books I bought? Here's where the issue is. We have become a society where judgments are made based on our behavior. And we have very great sophisticated technology that can use all the information readily accessible. Your financial records are not protected. Your communication records of who you called, when you called them, the like, are not protected. And by not protected, I mean not protected either by law or requiring a Fourth Amendment search warrant, communication, transportation, financial. And at what point do we put this in that big data analytics machine and begin to make conclusions about you that could be rational, logical, and entirely false? And that is the risk. We have all this data out there. We expose our own privacy data. We over-discuss on social media. And yet, at some point, people get upset. Just like this. Did they have the right to put this Supreme Court candidate's video rental history online? We have others, the Children's Online Privacy Protection Act. Again, in the scope of this course, I want you to read this, understand it, but do I want you to know this, explain it in details? No. Just one thing to note, this law is actually stricter about protecting children than under GDPR. And I've listed the California privacy laws and the Illinois Biometric Information Privacy Act because California has recently passed what we call GDPR Light. Excuse me, and Illinois has this Biometric Information Privacy Act, the rights of which of an individual were recently enlarged by court decisions. We have 50 states, but when a state like Illinois, Texas, New York, California, there's some key states passes legislation, the rest of the country takes notice. So as soon as this court case came out regarding this, all of my legal blogs picked up on it. Quite frankly, if it had come out of Arkansas or Montana, I don't think that would have happened. But Illinois is considered very influential. Now, we talked about this before in FTC in Chapter 1 about the FTC Act Section 5, but we want to be clear, we were talking about data breaches then. There are no on-point privacy regulations with the FTC. This is in a case-by-case handling of personal data. And again, a good document for you to review on your own time is the Protecting Consumer Data in an Area of Rapid Change, which we kind of laugh because 2012 is, well, that's 7 years ago. That's light years away. But here are the key points. It talks about privacy by design, and we're going to see this again in GDPR. where everything you do from the very beginning, before you write a line of software code, before you define that product, before you define a process in an organization, before you come up with some new scheme, you have to incorporate privacy protections. It can't be a bolt-on afterwards. And yet this was discussed by the FTC in this article 7 years ago. And you will see privacy by design as one of the key principles of GDPR. Simplified consumer choice. Don't confuse the consumer. Privacy notices. How many times a year do I get an envelope that I open it up and it's just the updated privacy notice in small font? I did ask my class if anyone had ever read them, and one person raised their hand, and I have to admit I have very rarely, I scan them occasionally. I very rarely read them. Another thing that FTC was talking about was the access. Consumers should have reasonable access to data that companies maintain regarding them. Well, guess what? Another tenet in GDPR. We are not that far away. We have some basic philosophical differences. We have some basic mechanisms that we don't have in place. Excuse me. And also the consumer education on privacy practices. They also published one on mobile apps, and I want you to be clear. This establishes the FTC's privacy expectations. They can bring actions. They can either order a company to do this, or a company can agree to do this, but it hasn't been statutory law per se. But they still have a lot of control. Now, I bring this up from President Obama. This is in your book, I believe. This is all great and wonderful and good and very aspirational. Here's the problem with this. First of all, Bill of Rights, we got to remember, let's be clear. Bill of Rights, first 10 amendments of the United States Constitution. They explained all this. My disappointment in President Obama is, why did he put this out and say this is what you should expect, but he didn't put any teeth behind it by putting it out as an executive order. So we can have these, and they're very aspirational, and we all live to this, and we all want this, and we're going to see this showing up in court cases. But guess what? It's not statutory law. HIPAA, protects your medical, anything having to do with that. It's got its privacy rule. Okay. Graham Leach Bliley was 1999. Phil Graham was senator from Indiana and former economics professor at Texas A&M University. Its privacy rule is less burdensome. It applies only to financial institutions, and it basically has a safeguards rule to provide security for non-public data. This last point here is, if you are familiar with the NIST standards, NIST always talks about technical, operational, and physical. Well, this is the same kind of three-way safeguards. Administrative, technical being anything you put in the technology, the firewalls, the intrusion detection systems, the physical protection. But then administrative is that whole how it gets done, how the people work, how the processes work. It's just a different name for operational. We've talked about this. If you like U.S. history, go read about Robert Bork. He had some history with Richard Nixon, supporting Richard Nixon. His failure to be confirmed as the Supreme Court of the United States was payback. I won't go into all the details, but it's the infamous or famous Saturday Night Massacre, which ultimately led to President Nixon resigning, where President Nixon ordered his attorney general to fire the special Watergate prosecutor. The first person refused, Nixon fired him. The second person refused, Nixon fired him. I can't remember how many people refused, Nixon fired him. Robert Bork was Solicitor General. He did fire the Watergate prosecutor on Nixon's orders. He later said his choice came down to, is it legal for the president to do this? And his opinion was yes, so he carried out the order. Now, we're going to talk about this a little bit because this goes back from something Tim Cook said recently. Excuse me. Tim Cook is the CEO of Apple, and he said privacy is a human right, and he's been very critical of Facebook. And I want you to understand human rights. It's a right believed to belong to every human being on the planet. The right to be safe against being massacred by the military, the right to food, the right to clean water, the right to education, all these kind of things. Sometimes people say civil liberties. This is just kind of my little OCD on this. That civil liberties, civil rights, human rights, they're not all the same thing. Human rights are fundamental. Civil liberties, your basic freedoms, and civil rights is the basic right of freedom from discrimination. We've talked about this. I've shown you this. And I want to end on this note. The next couple of weeks is going to be very interesting, but this course is what you make of it when you're taking it online. Where does our concept of privacy come from? I've included an article here from the New York Times. Most people think about Roe v. Wade from 1973 as being about abortion, legalizing abortion in the United States. It was not. The legal reasoning was about privacy, the right for a woman to make a decision, and that decision be between her and her doctor. The consequence of it was abortion in this country was legalized within certain constraints. The court cases in the 60s and 70s about privacy were about a couple being able to buy, a married couple, birth control in Connecticut, which was illegal. Roe v. Wade, Lawrence v. Texas, who a person chose to have sex with. They were about privacy. This is where our privacy comes from. And our best definition comes from a law journal article, Harvard Law Journal article in 1890, where the seminal ideas of privacy were entered into American law. 1890. This country was declared independent in 1776. Our Constitution was what? 1789. 100 years later, we begin to look and see what privacy is. And to keep that in mind, there are no strict, using the words privacy, rights in the Constitution. These court cases have inferred those rights to privacy by interpretation of the amendments to the Constitution. Louis Brandeis later became a Supreme Court justice. For those of you who think students don't have much power, these two guys were law students. They wrote a law journal article now, however many it's been, 130 years ago, that became the basis of American law. Thank you for sticking with me, and I apologize in advance for the terrible throat.